Okay, our next speaker is trial lawyer Sherrie Farrell of Dykema in Detroit. Prior to graduating from law school, Sherrie was a working journalist and PR consultant, skills upon which she draws in representing drug, auto, and construction clients these days in high-profile litigation. Sherrie is the managing partner of Dykema's Detroit office, the firm's largest, and she's been involved in big cases with national reach for large companies throughout her career. She was recently recognized among the best lawyers in America 2012 for commercial litigation, and she's prepared a top 10 list of litigation risk assessment tips for us today. Those are always helpful. Please join me in welcoming Sherrie Farrell.
Wow, that was a heavy introduction. Now I have to live up to it. I'm odd. I find litigation risk assessment issues fascinating, in part because of what John was talking about. I managed litigation nationally for a major auto manufacturer, and our cases were always in those judicial hellholes. But the approach that we used happened far before we actually showed up at the steps of the courthouse. And what we saw through our program is how you can manage risk, how you can manage cost, and how, in the case of my client, how you can tamp down growing areas of liability. And that's what I'm here to talk about, because as we all know, whether we're outside counsel or inside counsel, the pressures on litigation right now are tremendous. If you're in-house, you're likely being told by the business side, you need to decrease these costs about 20%. Yet you look at growing numbers of litigation cases in front of you and you wonder, well, how do I do that? Well, maybe the answer is to bundle all of my law firms, or maybe the answer is to do a lot of alternative fee arrangements. All of those are tools, but one of the most important tools is managing the risk early on, and it's a very intentional tool that we can use. Now, technology and me, okay. So hopefully this will work. So the first question that you need to ask is not whether a lawsuit will occur, it's a given. Somewhere along your career, the lawsuit will occur. So the question is not whether that lawsuit will occur, but the question is whether that risk of litigation and the actual lawsuits are being well managed. So how are you managing the risk of litigation? If it's not part of what your thought process is, if it's not part of your strategy already, then it's something as we move into 2013 you should be thinking about, because the pressures that you're facing are tremendous. So typically when we talk about risk assessment or risk management, and I use the two interchangeably, management and assessment, most folks are thinking of it from the trees approach. This is my docket of cases, or these are the types of cases that I manage, and I have case assessment or assessment of that docket based on what I'm faced with every day. I submit that it starts even before that there is a level of enterprise risk management that really is the forest. So it is both a forest and a trees approach, so that you start lowering the cost, looking at the risk intelligently and being informed, so that by the time you get to the case, it'll make a difference. So, do you know what those risks are? So let's get to the tips. Anticipation, no surprise here, anticipation and preparation, as it is in any area, a trial area, litigation area, are key. We can't ignore that a lot of work has to go ahead of us. Otherwise, we're kind of like the rock rolling down the hill. We're just going along with the litigation rhythm, and we should never be doing that. That means that we are not anticipating. That means we are not preparing. So, tip number one, as I said, is, whoops, I went too far. Tip number one is focusing on that whole enterprise. You know, and I know, that when the business side, when your clients see you coming, there's a whoo, here they come. Because it's seen as a disruption. It's seen as money going out the door. It's seen as, why are we defending this? It's not seen as a partnership. And that's in part because litigation and legal staffs are silos. Rarely do we add to the bottom line, we take from the bottom line. So an approach that I think needs to happen is a focus on the whole enterprise, so that that common direction of litigation risk management, just from the view and solely through the lens of the litigation portfolio or docket, is set aside, and the entirety of the organization is taken into account and brought along more as a partner as opposed to a disruption. How do you do that? You can align litigation and business strategies. Yes, litigation strategy is far different than a business strategy, but if you know what the business strategy is for your enterprise, it can make a difference. It will make a difference. For example, when I was managing litigation, a litigation area for this auto company, I knew what the business strategy was because that's kind of where I started my project. And so I was able to incorporate my knowledge of the business strategies into how, believe it or not, I managed discovery across the country, and it made a difference. You need to ascertain your enterprise's business and litigation tensions. Yes, they're there. We need to recognize that they're there. But how do we get past them? Well, you need to understand the tension between the litigation cost and the litigation benefit, and be prepared to tell your clients what that benefit versus cost is, and be prepared to defend it. And the only way you can do that is if you understand the business enterprise itself. Now, this is something for all of us. Are your litigation processes transparent? They tend not to be. We tend to kind of, again, work in our silos and be the very best advocates that we can be. But in terms of trying to determine risk analysis and risk assessment on the enterprise level, we need to be a bit more transparent. No, that does not mean that someone on the business side needs to know every jot and tittle of what you're doing. They'll throw you out their offices. But what they do need to understand is why this partnership is important, what litigation impacts have on the company. Because we know that when we get into litigation, we may interrupt an executive. We have folks we need to take to depositions. We have arbitration issues. We have trial issues. And that becomes very disruptive. It's a lot easier when that's anticipated and that process is understood and why we're doing it on the business side than when we're in the midst of the litigation itself. Now, since we're talking about enterprise level, we know that management requires metrics. And quite frankly, this is an excellent way to determine if the risk assessment that you put in place is working. We had numbers that we filled in every quarter, so that by the end of the third quarter of every year, prior to the general counsel, vice president and general counsel making a presentation to the board of directors, he had our numbers. He knew in terms of this particular program what was happening. He could see the trends. He could see the cost. One of our unstated aims was to drive those costs down. The client went from being essentially a second, third tier target to a first tier target, which meant that the cost for the target went up to, they normally would settle these cases in for a couple of $1,000s. Well, by the time we came aboard, the average jury verdict against our clients was in the multiple millions, and because it wasn't managed. It was just, here's the litigation, let's just keep going on. So because management requires measurement, you need to determine what are going to be your data points. The number of cases, the cost, the settlement, the time. How do you quantify time that a business person has taken away from what they're doing every day? How do you quantify that? Whatever you decide are your data points, then you have to figure out, well, how do I use them? In our case, we use them for a quarterly snapshot of the litigation so that we could not only determine the trends with respect to liability, but the trends in terms of cost. Then, after you have that information, you've got to develop an analytical procedure that will help ferret out and measure those correlations between the strategies that you've put into place and the litigation. Optimally, there would be no litigation, right? Well, at least for in-house. For those of us outside counsel, we like it. But anyway, the optimal plan is to avoid litigation. But we know that that's not realistic. So on the enterprise level, you also, particularly now, need to be paying attention to what's happening with respect to corporate governance, risk management, and compliance. You know that in the past several years, there's been increased attention, particularly to compliance, because of the increased regulatory environment that companies find themselves in. So you need to be ready to respond to that. And one way, if you don't have overall management of the litigation, say you're not the GC, is you can do a snapshot of compliance in your area to make sure that that information is part of the corporate information on an enterprise level. Another tool that you can use is for putting together an internal alternative dispute program. We do that when we're looking outside, but we need to look at what can we do inside the enterprise that may affect the cases that come through the door. And so know your employee disputes and know your culture. Customer complaints, what kind of impact would that have if you had an alternative dispute program in place? Supplier issues. A couple of years ago, a Japanese supplier asked me to help the business side come up with decision points because they had a troubled supplier issue that was upticking. So what I did is provided a manual that simply said, if this happens, then you need to be paying attention to this. If this happens, I did that in what was essentially 15 pages. Now, I assume that it's been very successful because I have not heard from that company to handle any troubled supplier litigation, but it is just one of the ways that this company decided to try and manage that risk. And it appears, at least at this point, that it's been successful 2 years later. So in order to do that, of course, you have to know what that risk is. And so, again, this goes back to looking at it from an enterprise level, not just your docket, not just your portfolio, and understanding the impact of, say, the global economy or wage and hour issues in your corporation, even risk posed by social media. There's a risk that is apparent right now on the consumer end because we have the Consumer Protection Bureau. What kind of impact can that or will that have on what you do day to day? So, what essentially we're talking about is creating business intelligence around litigation and that risk of litigation. And so it's clear that once we have that information, then we get to the nuts and bolts of risk assessment and litigation management. And that's because we'll know the type of liability that we may face because we've been keeping data on that. We can determine the frequencies with which we're faced with these lawsuits. We can even determine how many times the plaintiff's counsel have come up and in what jurisdiction is it Madison County. And how do we deal with Madison County? Is there a strategy? that is more appropriate in Madison County than in Detroit, Michigan. Because we've been getting this information, we can identify early on the zone of information. What I did in this small project that I briefly referenced initially was talk to business folks on the business side about areas of liability. The original project was just to do that. It turned into the national counsel role because the organization recognized no one else had made that bridge quite so easy. So even to this day, even though that liability no longer exists, I still have those business folks calling and inviting me to their homes on the holidays because it was an easier partnership. So when I had to depose them, they understood because they understood that up front, even before we got to a lawsuit. So we identify the zone of information, documents, witnesses, business units, and then we do things like, this is just an example, making sure our litigation hold processes are intact, defensible and repeatable. And defensible and repeatable really are the goals for litigation, risk assessment, and case assessment management. Then finally, on the enterprise level, something I just talked about, educating the business people, getting your document ducks in a row. We all know the importance now of e-discovery. You've probably been to a zillion conferences that talk about it because it is important and because litigation is changing in this area, and it can be in terms of cost insurmountable. So you want to have that ready. You want to work with a clear understanding when you're talking to the business side about privilege issues. Sometimes our clients don't understand the privilege and don't understand who the client is. And once you have all this information, and once you have this business intelligence, then you can do an informed preventive cycle. You can look for those patterns. You can quickly institute corrective measures. You can decide whether, once you've done your compliance audit, whether you need to update training and other policies. Now, far more recognizable for most people when you talk about case and risk assessment is doing it from the case level. So, and these are quick because most of you understand them already. Use litigation risk assessment as that framework. You've got a lot of information from the business side now. So now you can put that framework around the cases that you're dealing with every day. So you're designing your litigation strategy by identifying goals first, and then you design a course of action to achieve those goals. You understand the aspects of your corporation. Then you formulate and implement an intentional strategy. Litigation risk management and case assessment is intentional. Routine, low risk. You should know that when the case comes through the door because you've done all the work up front. You don't need to determine what type of case is this. You know when you see it where it falls on the line. Except for those routine, low risk cases, you always need to partner with either your outside counsel or someone else to do that initial assessment of the case so that you know where it falls, the general zone of cost for that case, which includes more than just the direct litigation cost, and then the desired outcomes and objectives. It's not just we want to win or we don't want to pay. It's far more than that. Once you have that, then you can look at making the decisions about the direction. Do we want to settle? Do we want to, this is a trial? And as you make those decisions, again, you've got a lot of information and you can be informed when making those decisions as opposed to just doing it because it's a tree just out there. So, including, will loss or settlement restart the clock, which is an important question. And then finally, because the cost of litigation it can be tremendous when you're doing discovery, this approach is absolutely necessary because what we found is that the cost for discovery started going down because we were very intentional about what we were doing. And so formulating an efficient upfront search strategy, defining the roles, all of this needs to go into your assessment to ensure that you're managing the risk appropriately. And the very final tip that I have is simple. Just do it. It's necessary. Thank you.